Good afternoon. Good afternoon. My name is Eleni Arvanitis Zorba, and I am a professor here at the University of Saskatchewan College of Law. It is my pleasure to welcome you to the college this afternoon, and welcome to those joining us on the live stream. We're delighted that so many of you could join us for today's lecture, as we are spotlighting one of our very own College of Law faculty members, Robin Hansen. As we gather here today, we acknowledge we are on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. On behalf of the entire college, I would like to say thank you to McKercher LLP for its support of today's lecture. The firm generously supports or sponsors several lectures each year, and we are very grateful to them. Thanks to McKercher, we can explore enriching and thought-provoking topics, not only with our students, but the broader community as well. As mentioned earlier, our guest speaker today is Robin Hansen, whose lecture is based on work she explores in her brand new book, Prison Born: Incarceration and Motherhood in the Colonial Shadow. It's published by the University of Regina Press, which describes Prison Born as a scathing critique of the colonial legal system's denial of children's rights. The publication of this book has been years in the making. It started with a phone call that Professor Hansen received in 2016 from Jackie, a pregnant Indigenous woman who was going to give birth in 9 weeks and faced the prospect that her unborn son would be automatically separated from her. Professor Hansen's work on this case is a testament to her compassion for Jackie, and bringing this book to press is the result of a lot of hard work and a desire to shine a light on a practice that violates the rights of women and their children, the majority of whom are Indigenous. Robin Hansen is an associate professor here at USask Law. She specializes in international law and teaches public international law, conflict of laws, and human rights. Her primary research interest is on how legal personhood is constructed with legal systems, and particularly how this construction frames accountability. Her work has also been published in journals including the Modern Law Review, Global Jurist, and the Journal of Legal Education. Please join me in welcoming Professor Robin Hansen.
Thank you so much for being here. Thank you to everyone online. My talk today is called Prison Born: Colonial Racism and a Systems Theory of Law. It is based on the book that has just been released. A couple preliminary comments. I'm going at this topic as a settler. There's very offensive language that's going to be used, and quite serious, heavy topics. And so my goal is to share the research very respectfully and to use quotation marks and context to frame the discussion. There are 5 topics within the talk. First, I'll talk about automatic separation of newborns from their mothers. Second, about how it's a serious human rights violation. Third, that it's happening because it's directed by the Canadian legal system. And fourth, because the system contains and communicates dehumanizing definitions of Indigenous persons. Fifth, these definitions must be rejected as antithetical to a just legal system. So, automatic separation of newborns from their mothers in Canada. I did access to information requests for all the jurisdictions of Canada. Not everybody had information, but for instance, with a 5-year period in Ontario, there were 26 births that happened to persons in custody, and in each one of those 26 cases, the child was automatically removed from their mother's care. This was the same as in Alberta, which had 15 such separations in a 5-year period. Saskatchewan was 7 for that period. And so while I didn't have information for every jurisdiction, because all the jurisdictions in Canada, except for the Northwest Territories and British Columbia and the underused federal mother-child program, because all of the other prison systems in Canada do this, I would estimate conservatively that at least 45 children a year are automatically being denied without any due process the opportunity to bond with their birthing parent. So it's not surprising when we think about how there's just under 3,000 women incarcerated in a given month. March 2023, it was 2,800. And so if 5 to 20% estimates range of those women entering prison are pregnant, it's unsurprising that births would happen in prison. Now, this is a Canada problem. It's also a colonial problem. It's happening to non-Indigenous women as well. I get into that in the book, but I'm focusing on Indigenous over-incarceration today because that is the focus also of the case study in the book. So this is a colonial problem in that it's vastly disproportionate, that 85% of women in Saskatchewan jails are Indigenous, 17% of Saskatchewan population is Indigenous, 50%, more than 50% of federally incarcerated women in Canada are Indigenous, just under 5% of the general Canadian population. So grossly disproportionate effects. So that's automatic separation. It's a serious human rights violation of the mother. I'm focusing on the child. That's the emphasis of the book. So in most of Canada, newborns are routinely separated from their mothers by corrections without consideration of how this will impact these infants' mental and physical health. Bearing in mind that the Canadian Pediatric Society describes attachment as the deep emotional bond between a baby and the person who provides most of their care, noting that attachment is the first way that babies learn to organize their feelings and their actions by looking to the person who provides them with care and comfort, noting that attachment is essential to long-term emotional health. Canadian Pediatric Society. So with automatic separations, we have a clear example of what is known as the science policy lag, where science clearly says one thing, policy is just not there. We know that bonding is required for development. There are designated illnesses, reactive attachment disorder, disinhibited attachment disorder that are related to a young child's lack of sustained bonding. So we have this clear connection between bonding and physiological, emotional, mental health development through the lifespan, starting at birth. Look to Penelope Leach, world-renowned child psychologist, author of Your Baby, Birth to 5 Years, noting recent research writing in 2016, the connection between bonding with a caregiver and the development of chemicals such as norepinephrine, the permanent scarcity of dopamine neurons. This is a clear, there's a clear correlation between denial of bonding and mental health development, or lack thereof. So when a child is automatically, without anyone actually looking at the situation, when a child is taken from their mother, who would be available to provide care, and, for instance, placed in a group home with revolving caregivers, which has happened, can happen, this is a violation that is directed by the legal system. So what is the legal system? I'm looking at the legal system from the sociological theorist Niklas Luhmann, seeing the legal system as a network of communications, just like society itself is a network of communications. So the legal system is a functionally differentiated subsystem of society. It's doing something. It's organizing what is legal as compared with what is coded as illegal. Niklas Luhmann, very well known in Europe, less so here, very prolific social theorist and lawyer. By a systems theory of law, we trace the communications within the legal system to see the law. When expectations are communicated amongst actors in the legal system, and those expectations of what is legal as compared with illegal match, those matching expectations form the legal system itself. So the legal system is a self-replicating network of communicated expectations of what the law is expected to be. Interestingly, silence is acquiescence in this. You can have matching expectations when only one person is communicating and the other person is silent. That is sufficient for expectations to match. So the legal system communicates changes according to the rules that it sets for its own change, such as by new legislation. It is a closed system operationally, an open system cognitively. It is also essentially amoral. It's whatever we human beings make it. It's not inherently connected to morality by this sociological understanding of law as a social system. It is instead simply a binary of what is constructed as legal as compared with illegal within this legal system. So within our Canadian legal system, there is a direction that certain newborns be granted within that system zero constitutional rights regarding who cares for them at birth. Instead, the legal system strips the rights of the baby pre-birth during the sentencing of the mother. So there's an automatic denial of an available birthing parent's care and bonding, which can represent an extreme health deprivation. If we trace the system communications using systems theory, what's happening? A pregnant woman is sentenced. The judge makes a determination communicating that a given custodial sentence is warranted. That's stage one. Also at stage one, a second implicit determination is also made at that time. The judge looks at the pregnant woman, is informed that there's no place for that woman's child in jail, yet sends her to prison with a sentence that well exceeds the time before her due date. The only way this sentence can be rendered is if the judge not only considers the crime, but also determines, without actually declaring as such, that the woman's worth as a mother is such and the status of the coming child is such that it is acceptable under the law for her child to be taken away from her care at birth, that it is acceptable for said child to be deprived of their mother. So the judge sentences the newborn. And then when the child is born, the child is separated from their mother by administrative actors, corrections, social services, and this administrative act is made as a matter of course because the child is not permitted to remain with the mother due to corrections policies. During sentencing, the judge does not assess the woman's capacity to mother, nor the effects of separation on the well-being of the child. At that stage, the child is not yet born, so what's happening at sentencing is the child's future rights are being preemptively denied to them. This is a serious violation of Section 7 of the Charter. A newborn's removal from his or her mother without any review by the state of the child's individualized circumstances is a violation of the child's constitutionally protected right to security of the person. The physical and psychological integrity of the newborn is clearly affected by a decision that denies a mother's care, constituting an interference with the child's security of the person. And this interference is not in accordance with the principles of fundamental justice because it's made without fair process. Here there is, in fact, no process of decision-making since the separation is automatic, presenting a clear breach of the fair process obligations that apply in state decisions affecting a person's Section 7 interests. So how does the legal system contain and communicate dehumanizing definitions of Indigenous persons, noting that In this case, this is an Indigenous child that this almost happened to, and considering over-incarceration, it's in many cases Indigenous children that are facing this. I do talk about in the book non-Indigenous children having this happen to them, but that is a separate line of analysis, focusing on why this is happening to children like Yuri, who is the person that I worked with, his mother. So regarding dehumanizing expectations in the legal system against Indigenous persons. The Canadian legal system is built on the expectations of the British and Canadian authorities and was expected to realize the colonialism of Canada. The legal system was expected to facilitate the dispossession and spatial containment of Indigenous persons as part of the development of Canada as a colony. And this should not be a controversial statement, given the bare reality that Canada is a state made by a foreign power in an area where there were clearly people living here first. Haudenosaunee scholar Patricia Montour, a brilliant scholar, writing in her seminal work, Standing Against Canadian Law. Think about everything that First Nations people have survived in this country. The taking of our land, the taking of our children, residential schools, the criminal justice system, the outlawing of our potlatches, sun dances, and other ceremonies, the stripping of Indian women and other Indian people of their status, everything we survived as individuals or as Indian peoples. How was this all delivered? The answer is simple: through law. For almost every single one of the oppressions I have named, I can take you down to the law library and I can show you where they wrote it down in the statutes and in the regulations. Sometimes the colonialism is expressed on the face of the statute books, and other times it is hidden in the power of bureaucrats who take their authority from those same books. The problem is that terra nullius lives on in the communicated content of Canadian law. This idea that Canada was empty, terra nullius, and this is a bedrock dehumanizing legal assumption that's circulating and denies full personhood when it is communicated to Indigenous persons. It denies full personhood and treats them in law as not counting as full people, as full citizens, very commonly defining Indigenous persons as inherently uncivilized or as disappearing or dying naturally. And that's because how could the land be empty if that was not the case? So specific dehumanized definitions of Indigenous persons, which were and still are circulating within Canadian law. There's Indigenous specific offenses that have evolved into over-policing. There's dehumanized definitions that are entrenched by widespread denial of Canada's colonial crimes. And so these racist definitions and understandings require express rejection in legal system communications. Otherwise, they will reverberate and amplify in the system code, considering that silence is enough for expectations to match. For context, a very brief review of Indigenous unfreedom as constructed in Canadian law. Canadian law was characterized by broad statutory basis and expansive discretionary powers for Indigenous incarceration. Anglo-European settlers did not have to worry that consuming or possessing alcohol would lead to immediate imprisonment, whereas Indigenous persons did. There was, from 1881, the Indian agent's power to serve as judge and order incarceration over all the offenses in the Indian Act, including alcohol rules, a very low threshold offense called Indian prostitution that you could be found guilty of merely because of where you were. Also could prosecute for vagrancy or meeting in groups of 3 or more. Also, severe restriction of movement through the pass system with enforcement of this pass system policy through vagrancy laws. Also serious unfreedom regarding economic activities. jail for ceremonies, jail for resisting abduction of your child to go to residential school, illegal to make a claim against the state. For instance, in the 1920 Act outlines incarceration of up to 10 days for failure to have your child sent to residential school. And then enshrined in law and policy, the residential school system itself, with 150,000 children forced from their families at young ages, severing attachments, the very detrimental effects of the institutionalized environment, the racism, abuse, torture, deprivation, and death in many cases. So the formal changes that started to happen after World War II to Canadian law in part happened because of lobbying from Indigenous veterans who would return back from putting their lives on the line for Canada and couldn't even go to the Legion halls because alcohol was served there. So after the rewriting of the criminal code in the 1950s, the low threshold Indian prostitution offense was taken out. Dry Bones in 1970 struck down the alcohol provisions. Tommy Douglas had changed Saskatchewan laws about 10 years earlier. So the official rules changed. But there's still inertia in the system because there was still communicated expectations of criminality and inherent threats that were operated upon and are operated upon. And this is because of inertia in the system and the fact that the binary of being civilized and uncivilized has not adequately been rejected from Canadian legal system meanings and practice. And that there's still implicit definitions of, quote, savages and quote, dying persons circulating in communication, bearing in mind that silence perpetuates these communications. And also lack of representation of Indigenous persons as judges, politicians, and in public service contribute to this inertia within the system. So, for example, there's no longer official discriminatory provisions regarding alcohol in the books after 1970, but we still see disproportionate enforcement of generally applicable law against Indigenous persons. So being targeted for being intoxicated in public more than non-Indigenous persons because of this continued expectation that it is illegal to be drinking when you're Indigenous. This is a little bit like how, this is not to make an equation, but just to describe the mechanism. For instance, with the ending of homosexuality being a criminal code offense, still, more than 10 years later, there's Operation Bathhouse in Toronto rounding up 300 men from a bathhouse. So expectations that continue in the system that don't change formally with the formal law, that's what systems theory looks at. So the discriminatory operation within the Canadian legal system vis-a-vis Indigenous persons, there's over-policing as this hangover from official offenses that targeted Indigenous persons. So highly policed, 10 times more likely to be street checked in Edmonton. Also more severe sentences when it comes to judicial sentencing. In some cases, double the sentence length, according to research by James T.D. Scott, published in the Criminal Law Quarterly. So there's discriminatory operation of the Canadian legal system still as it operates. And there is thus very problematic over-incarceration. Recent stats, 8.9 times the rate of incarceration for Indigenous persons as compared with non-Indigenous persons for territorial and provincial jails in Canada. 12 times the rate of child apprehensions in the TRC report, 12 times more likely to go murdered or missing by the MMIWG interim report. So skewed operation of the legal system. And in the book, I get into many specific examples where the legal system does not offer full personhood to Indigenous persons, like Cindy Gladue or Tina Fontaine or or Betty Osborne, But the overarching idea is that because of this colonial expectation, there is differential personhood, sub-personhood being communicated in the legal system. In the words of Rufus Prince, former vice president of the Manitoba Indian Brotherhood, we can trace, and this was reported in the Manitoba Justice Inquiry, we can trace an unbroken record of injustice back through generations to our grandfathers and our grandmothers, our great-grandfathers, and to those before them. We can trace them back to the time when a label was put on our people, legitimate victim. Other people learned that they could victimize us and nothing would happen because the laws, your laws, did not protect us. So how can dehumanizing definitions be rejected within the legal system in order to make it a fair system for everyone and to not implicitly deny people's rights? This is the example that was alluded to in the introduction. So in 2016, I ended up representing a woman who didn't have representation for her appeal. She was 6 months pregnant when she was sent to prison for 13 months, which was 1 month less than the prosecution had sought. It was her first offense. She did not have a criminal record at the time. And she, while impaired, had gone back into a bar and shown scissors and to get more alcohol, and so was charged with armed robbery. She was in prison for a month afterwards and then on house arrest for 6 months. And so she got pregnant during house arrest. And also when she was on house arrest, she got treatment for alcohol. She was cooperative and remorseful, and yet there was zero consideration of the fact that she was low risk by in the sentencing court. And this was because when she was in the court, she was treated as if she had no value as a mother to her child, because it was known in the court that her child would be automatically removed, and yet the judge still cited her pregnancy as a neutral factor and made comments such as, in her culture, is it a bad thing to be raised by a grandparent? And also dismissed any sort of colonial impact on her background because she had taken some college classes, so clearly she didn't have any problems of dislocation. And besides, those resources that she had for her education had somehow meant that she was without any sort of Gladue considerations. So she was sent to prison, and I don't know the details why, but probably because of resources, she didn't have any lawyer. And so I'd been talking with lots of people about this general problem because I had found out about it by reading the Inglis case, which was a 5-year charter challenge to bring back the mother-child program when a deputy minister for corrections unceremoniously canceled it because of political pressures, stating that infants were not within the mandate of corrections. So I was not happy about this topic because I read the Inglis decision when I was pregnant, and I could easily see how awful this would be to be separated from your newborn and have the newborn have such upheaval. So in talking with people in my communities, eventually Jackie called me, and I tried to help her find a lawyer, and I couldn't find any lawyers. And so then I was her lawyer, and I asked all the criminal law people I know what to do, and they helped me. Thank goodness. So it's all explained in thorough detail in the book. So she was sentenced to prison. Her child was also sentenced. She was constructed fully as a non-mother in the courtroom. She didn't get adequate care at all in the prison. They didn't treat her gestational diabetes, even though it had been diagnosed before her incarceration. And she went into labor, and she was ignored for many hours. It was only after the prison health staff had left for the night that she left in an ambulance. They put leg shackles on her in her labor, right from when she was leaving the prison. Even in the hospital chart in Prince Albert, she was noted to be shackled. She was in leg shackles driving from Prince Albert to Saskatoon because she had a ruptured placenta. And very, very serious health issues and terrible treatment arose. So after her birth, after her son's birth, very thankfully, corrections allowed her to have escorted visits to visit her son in the NICU. And very thankfully, the Ministry of Justice prosecutions persons agreed to a consent judgment switching her incarceration to longer house arrest so that once he was out of the NICU, they could be together. So they were not separated in the end, but that was only because after her sentencing, there was a wrench thrown into the operation of the legal system that said, hey, there's a child here. This child has rights under the Convention of the Rights of the Child. Are we going to do something better than unceremoniously deny him bonding? And thankfully, people rose to the occasion. But the system, as it was going to happen, and as it has happened since then, no doubt, in Saskatchewan and all across Canada, is not happening in a way that takes the children's interests into account. So the reason that this separation was averted was because there was pause given into the system to look at the fact that actually she had great value to her child in caring for him, and actually he is a real person that needs to have his rights considered when the state does something very serious towards him. And so those key definitions, those key dehumanizing definitions were rejected in the legal system communications in the appeal. This was different, of course, to the original sentencing. So what happened in the original sentencing? There were key dehumanizing norms that were being communicated. The first norm is that as an Indigenous woman, she was somehow an uncivilized, unfit mother, amplified, of course, by the fact she was in a criminal court, so automatically stamped as not having value as a mother, noting, as I mentioned, that in her culture, is it a negative thing to be raised by a grandparent, noting that her pregnancy was presented as a neutral factor. So that is a key norm that needs to be rejected in the courtrooms. The second dehumanizing norm that needs to be rejected is this idea that Indigenous persons are, quote, savages, that when they transgress, quote, civilized law, they require containment and imprisonment since they are threats to Canada. This old colonial idea of inherent threats, the goal of the legal system being containment and dispossession, has to be rejected. The secondary idea that Canada is never uncivilized and any abuse of Indigenous persons by Canada is without legal weight also has to be rejected, because widespread denial is buttressing anti-Indigenous ideas. So there's a connection between denial and oppression. The denial seen in her sentencing took the form of seeing the fact that she had taken college classes as meaning that she had no colonial trauma and that there shouldn't be any specific sentencing approaches taken, and that not only had she taken classes and so was presumably whole, but there was reference made to resources from Canada for her education. So the prison idea, we can't continue to assume that prisons are just for society's trash. That we can't keep assuming that prisons are where dying or disappearing people just kind of get shuffled, or uncivilized persons that have to be contained. People in prison are people, and they need to be treated with full humanity. Instead, if we see prison as a place for the dying and the uncivilized, then all the pain in prison gets absorbed into this idea and somehow justified in this idea. So we get the denial of medical care, we get the labor in shackles, which since then has been addressed by a specific policy against that. And all of that is acceptable in the neglect and pain of prison. Noting that there's contrary examples in operation in Jackie and Yuri's case where they allowed escorted visits to happen after the birth and treated them as real people instead of assuming otherwise. The last communicated expectation that I look at in the book is how there are dehumanizing norms attached to understandings of Indigenous children, really present in all of the colonial policies that I talked about. This idea that it's in the best interests of the child for Canada to always take away the child from its uncivilized and disappearing family in an attempt to civilize it. So by this rationale, this is how we continue thinking that it's unremarkable that a child, when they're born, automatically goes to social services without an individualized review. That's this overarching idea, well, of course it's better. Well, that's something to be rejected now. So he was poised to be separated from his mother. This was even noted in his hospital chart, and this is according to a blanket level policy in a province where 85% of the women in prison are Indigenous. And as I mentioned, contrary expectations were communicated once the system was given some pause in that escorted visits were permitted, and eventually the consent judgment was arrived upon. So in order to reject dehumanizing communicated norms within the legal system, we have to have the legal system in such a form that it's directing the legal system to apply rights to everyone. So there needs to be a foundational rejection of the presumed worthlessness of the mother to her coming child in the courtroom communications. That is an assumption that can no longer be allowed to operate unchallenged. There has to be insistence that the child's right to health and to family be considered under the United Nations Convention on the Rights of the Child, to which Canada is a party, and under section 7 of the Charter regarding fair process and rights to security of the person. And so these rights apply in sentencing and also vis-a-vis corrections conduct. So automatic separation of newborns from their mothers is not a valid part of the legal system. It breaches the Convention on the Rights of the Child and the Charter, and just like a break from past practice occurred for Yuri, thanks to willingness of corrections and the Ministry of Justice personnel to reflect on the child's best interests when prompted to do so, this practice can be ended by those with proximity to it. It can be ended by those in the courtroom rejecting the fallacy that it's acceptable to punish children. So in sum, automatic separation of newborns from their mothers is a serious human rights violation that is directed by the Canadian legal system, in part because the system contains and communicates dehumanizing definitions of Indigenous persons, definitions that must be rejected as antithetical to a just legal system and, of course, to reconciliation. So that's everything. Thank you very much.
Thank you, Robin, for bringing to light such an important issue. Now, we have a few minutes, so I'd like to open up the audience for if anyone in the audience has any questions. We have mics on either side of the aisle. No questions? Okay, I have one.
Sure.
How did you, this is so out of your area, right? I am so curious. I haven't read the book, so it sounds like it's in there, but how did you get involved? How, were you
yeah.
going to court? How did you make this happen?
I think the issue that connects my previous work on multinational enterprises and human rights violations in that context to this is that it's still about legal personhood and still about querying cases where legal personhood is being treated in a distorted way by the legal system. So here the legal personhood of these children is just somehow not there. It's not being acted upon. There's no space in the system for it to be acted upon. So they're being marginalized by the legal system in terms of having the right to have rights, in terms of having the capacity for rights and obligations within the legal system. So I think that was the thread running through my previous work in international legal personality to this, which is, why is there the denial of legal personhood in this case? And I think that, you know, you never know what is going to really captivate you as a researcher. And I think that we're always responding to our society and to clear phenomena around us. So I think that I got into it just by being engaged in the violation that was so obvious.
Okay.
Oh, I think maybe.
Okay.
Oh, are you gonna? Yeah.
Coming to present. Okay. What do I want to say? So we've reached the end of our available time, and thank you everyone for coming today. I was told to remind you that we have a door prize for anyone interested. Please come afterward and put your names in. And now to wrap up, I invite Hannah Bouvier, one of our law students here, to come forward and officially thank Professor Hansen.
Oh.
Sorry. No, I'm sorry. Just before we round up, I was just wondering and pondering, you referred to this as a practice that is widespread, virtually all the provinces. Has it never been challenged? Never been, has this practice never gone before the court, especially since it's a clear violation of both the international undertakings and even the Charter of Rights? Has there never been an instance of a challenge?
It's never been challenged, and in fact, it was a challenge to bring it back when it was taken away in British Columbia. So the Inglis case, INGLIS case, that was, as I mentioned, an example of advocacy to even have accommodation of newborns in correctional facilities once it had been unceremoniously taken away. So it's a very underserved area of Canadian society with not enough access to legal representation, and as a result, it has never been challenged. Thank you for your question.
Thank you, Professor Hansen. It was great to hear about your lecture and about your research that you've done so far. It was really interesting. So
Thank
on
you.
behalf of the faculty, staff, and students, we'd like to thank you for coming to speak to us today.
Thanks, Hannah.
Thank you.